week as well as the previous week, and they have intensive courses on digital law related aspects. So it's a great pleasure to introduce this online workshop on legal design, which lasts until 1:15. For my turn now, I will just introduce few notions about legal design before introducing the expert who just arrived from Paris. For now, just a few words about what is legal design. We realized in the previous presentation that some participants did not know yet what is exactly legal design. So I just wanted to, and we just wanted, on the name and on behalf of Professor Tamò-Larrieux and myself, introduce you a few basics. So basically, what is legal design? It's a way to improve understanding of legal and or complex information in order to make the justice fairer and more accessible. And how to do so? We will do that with the help or in the intersection of law, technology, and design. And design could be, for instance, the choice of words, of language we use, but also visual designs, diagrams, maps, and schematics. Briefly about how it comes from. So actually, laws, before being encoded into textbooks, in the past, laws were singing. And apparently, our ancient colleagues said that when the law was singing, it was much more understandable. And it became more complex and not so accessible or not so understandable when it came into textbook, and it has been encoded into text. So from singing to text, and therefore, in the 90s, there were also some movements, like in the US, trying to make more easily understandable the laws, and we came with the concept of plain language. Maybe you've heard about plain language. President Clinton in the past, in the 90s, then Barack Obama decided to adopt regulation on how the laws need to choose some specific languages in order to make them more understandable. And that's the concept of plain language. That's in the 90s. And more recently, designers such as Audrey, Pety, our guest speaker, and other technology experts realized that with the help, not only with some choice of languages for plain language, but also with design and technology, things of AI-powered tools, the laws can be more accessible. And therefore, we came from singing to text, from text to plain language, and today to legal design, again, at the intersection between law, technology, and design. Here, and the slides are available, will be available on the platform as well as on your participant of the summer school Moodle platform. Here, some slides coming from Aurélia's presentation. You have a set of suggested definitions, and they are here highlighted for some components that shows you the efforts to make laws more than understandable. In yellow, you see how to improve the achievement or the understanding of the regulatory regulations. In orange, you have also with the help of visuals, such as charts, schematics, or diagrams. Turquoise, also how to make the laws more user-centric. And in green, public participation, how to get people more engaged. So the more the law is understandable, the more engagement we will succeed with public participation. And finally, in purple, we have also UX or other tools that improve understanding of laws. That's exactly what I've said. With the intersection of law, design, and technology, we can use AI-powered tool or other technological tools that make the laws more understandable. Last but not least, let me mention just a few examples of either initiatives or areas in which legal design is very promising or shows improvement. I've chosen 4 examples. Example number 1 is, for instance, blockchain and Web3. At the Geneva School for Art, we have colleagues who developed icons showing and explaining very briefly the different notions of Web3 and blockchain. For the sake of time, I will not pass through all of them, but you have the link cryptokit.ch, and you'll see every component of the Web3 and blockchain is represented visually by very understandable icons. Think of Creative Commons, these standardized licenses, and these colleagues have get inspired by similar approaches in order to make Web3 and blockchain understandable. So you have DAO, for instance, decentralized autonomous organizations, cryptocurrencies, and miners, and so on, who are represented. Example number 2 is the area of health, particularly health literacy. So you've heard about AI literacy. By the way, there is now a new provision into the AI Act that dedicates specifically AI literacy. So the EU lawmakers are very concerned that people understand what is AI. And now there is a new notion of AI literacy. Similar to AI literacy, there is the concept of health literacy, the idea that patients, people understand what the doctor says, what the healthcare system is about to care about them. And the more people understand health literacy, the better and the most efficient will be the health system. Example number 3 is in relation to vote and democracy. So you see, we moved from technologies such as Web3 blockchain to health and now to vote and democracy, because a unclear legal design for voting, at least in Switzerland, because we are used to vote many times, an unclear legal design of the brochure, information brochure, can lead to a cancellation of a whole initiative or voting. And therefore, the more the legal design, the better the legal design of a brochure is made, the most efficient and the most secure we have voting. So you see, it's also an issue of vote and democracy. Last but not least, example number 4 is privacy, of course. And that's why we look forward to hearing our guest speaker talking about privacy, because privacy, you had this lecture on GDPR and all the privacy requirements, particularly in relation to 1, the consent requirement, and 2, the duty of information from the controllers and processors standpoints. For the consent requirements, we've seen last week under the GDPR lecture that there is a high level of requirements in relation to the consent, at least under the GDPR, because there is a need to have a freely given, specific, informed and unambiguous consent, which is very high to achieve. And therefore, we'll talk today about how to achieve this theoretical consent requirement into a concrete understanding and projects. And indeed, according to studies, I mentioned last week that apparently 99% of privacy policies are not understandable to high school graduates, and it would take the average of 244 hours to read the entire privacy policies of websites users visit annually. So we've spoken last week about the biggest lie in the universe is that we agreed to the terms and conditions. We spoke also about privacy resignation or privacy paradox. We'll see today how to turn this theory into practice to enforce our rights. Linked to the consent requirements, there is also an increased information requirement, at least under our privacy laws, such as in Switzerland and the GDPR. And let me just highlight this very recent scandal or case. You may remember that until May 27th, you could, from an EU standpoint, opt out from Meta AI or other AI tools if you did not want to have your public posts used by Meta for AI training purposes. And for all internet users who have not opted out, I don't know who in this class, actually, can we ask you who has opted out? So for participants online, we have maybe 5 participants among 35 participants who have opted out. So for those who have not opted out, Apparently, Meta AI can, since then, generate AI responses and also use all these public posts, but also the Meta AI tool contains a share button that can post every chat to a public feed. And some users have unintentionally shared private conversation by clicking on this share button, and they have made their conversation with the chatbot publicly. And apparently this is due to an unclear privacy settings in the Meta AI app. So in my view, or in view of different experts, the problem is that Meta AI contains this share button to post chats publicly, but many users did not realize this button due to unclear privacy policies and made their conversations public. So the idea today is indeed to discuss how to turn theoretical requirements for consent and or information into practice. And for that topic, great pleasure to welcome our guest speaker, Audrey Pety, who is a interactive designer who used to work extensively on the protection or digitization of digital native cultural heritage with the Bibliothèque Nationale Française. And now she's part of the LINK laboratory within the CNIL, the French Supervisory Authority for Privacy. And she is dedicating her time on different projects within the CNIL to address indeed these theoretical requirements into practice. Great pleasure to welcome you, Audrey. So you have 30 minutes maximum so that we have time to exchange with participants online and or on site. For those online, you can use the chat function or raise your virtual hand so that we can see if you want to take some voice. And otherwise, we will be happy to take your questions and or observation within in 30 minutes. Audrey, you have the floor.
Great. Okay. Well, thank you very much for that great introduction, and it's a pleasure to be here, especially because it's great to connect with a legal design network that I hope will be growing even more and in the future. And I hope you will, after this presentation and the great one you will have in these sessions, you will also turn into legal design ambassadors, because we need more. So you already had my brief presentation, but I am an interaction designer. And even though I'm going to talk about legal design and consent requirements, because I'm coming from a design background and I'm not a legal expert, I'm going to explain how to turn that theory into practice. But first, CNIL. So as you just heard, CNIL is the French Data Protection Authority, la Commission Nationale Informatique et Liberté. You see its website there. And so CNIL was created in 1978 with the vote of the Informatique et Liberté law. And then in 2016, on top of the regulative and enforcement mission of CNIL, CNIL started to support innovation. And shortly after, the LINK was created to accomplish this mission. So LINK is CNIL, the Digital Innovation Lab. So it's le Laboratoire d'Innovation Numérique de la CNIL. And so I encourage you to visit our website, where we post articles, states of the art on various subjects. We have various publications, and we organize international events which are broadcasted online. So you might find interesting things on economy, legal design and design, but also cryptography, sociology, etc. And so at LINK, we are a small interdisciplinary team of 7 people. We are 2 innovation and foresight experts, 2 are research and development experts, engineers, which work on our intern tools and prototypes. And we have also 1 digital sociologists and 2 designers. And I have to say, Having innovation lab is quite rare among DPA in Europe, but having designers, and especially two, is quite unique in Europe. So it's a very special configuration. And that's why we can speak about legal design. Oh, okay. My icons are changed on that version of Windows, but okay. But to come back to our topic, so consent requirements. Before entering this topic, I will need to start with a question, which is, does design really impact data protection? Because if not, if the answer is no, then I have nothing to do in front of you today. So how can we measure the impact of design on data protection? So to measure that, I have a second question, which is, have you ever clicked here? So you probably never clicked there. Okay, maybe you don't see very well. Like that's better. So maybe you never clicked there because this is the first advertisement banner, which was posted on the website Hotwired in 27 of October 1994, if I recall. So this is often considered as one of the first examples of manipulative design online. So even though you probably never clicked there, maybe you clicked here. So I forgot to translate that, but it's a simple classic cookie banner with your cookie preference, your cookie settings, and then the accept all. And strangely, the refuse all button is not here. But maybe if you never clicked there, maybe you've clicked here, or here, or here, or here. Well, it's quite hidden by all the Zoom interaction, but you can guess the idea. So to measure the impact of design on behaviors, we took this example of cookie banners, and we made a study with the French interministerial team, which is dedicated to this kind of studies, in June 2023. And we made an online randomized control trial to see if design have an impact on cookie banners. So we measured, we tested various designs. One which would be like a control banner where the button accept all and reject all are on the same level. Another one, deceptive design, where by default the accept all button is the only one on the first level. And to have the refuse all button, you have to personalize your choice, your settings. And another deceptive design, which is having visually highlighted the accept button and having some kind of hierarchy between the buttons. And we tested the opposite practice. So, for example, swapping the hierarchy of the two buttons, or emphasizing the consequences of being traced. So the consequences of the accepting or refusing. So accepting to be traced in French, or continuing without being traced. And finally, we tested another visual metaphor, which is the one of the three-color traffic lights. And so here are all the banners we tested. So which one do you think had the lowest refusal rate? If you heard what I said, it's not really difficult to guess. So do you think it was the first one, the control banner? Maybe not. Yes, exactly. The second. So for the first row, when the people were facing the two buttons with the same level, then we were around 17–18% of refusal or personalization rate. But when we had the default deceptive design, the refusal rate drops down to 4%. So we really see the impact of design on consent. But also, when we were trying to test the opposite practices, then we see a significant raise of the refusal rates. So actually, we have these refusal rates to show that design has a real impact on consent. And we also learned something else, which is that this design have a learning effect learning effect on us. So we had the beginning of an evidence of that learning effect because the participants were confronted to 3 banners in a row. They didn't knew we were testing them on cookie banners. We were testing them on various websites. But actually, what we were looking for is what their interaction with the cookie banners. And so when they were confronted to 2 deceptive designs and then back to the control banner, we saw that one habit, even though it was a very short-term observation, we saw that there was still a significant impact because the deceptive design had a 4% refusal rate, as we just saw. But the control banner initially, when you just see only in a row 3 control banner, the refusal rate was around 18% of refusal. While when seeing twice the deceptive design, the refusal rate drops down to 10%. So this is the beginning of an evidence of a learning effect. And actually, we can understand that learning effects is habituation because here we can see a heat map of the position of the interaction element on cookie banners. We see that the position of the accept button is really located in the same place on average, while the position of the reject button is decomposed around diffused around all the corners of the cookie banner. So it's for users, it's really harder to try to build some kind of habits when they want to refuse. They have to search for the button. And this can be explained because this is all this interaction is structured by the habits of designers and the design guidelines that are spread around all the internet. Because so when you're designing a website, actually designers don't know quite well the regulation. What is important for them is that they use design systems. So design system is a collection of various components which are pre-prepared, pre-made. And the most famous one, one of the most famous one, is the Google Material Design design system, where you can just borrow their buttons and their interaction elements, and so you just copying what they did. But Google is not the only actor. There are lots of, almost all websites are structured in the same way. For example, here you have the example of the design system of the French government, which also had the same kind of structure. So it's important to know that these codes are spread around designers because this is what makes our habits as users. For example, here are Google's Material 3 buttons, and you don't need to be designers to understand the significance of each one of these buttons. You don't need to be designer to know that, to have subconsciously learned that some buttons are default buttons or some activated, unactivated. And so all this subconscious learning is really structured by the design ecosystem. So it's important to understand that because it's really structuring how we see and understand websites. And so that's why it's important for data protection authority to also connect with this design systems ecosystem. So to encourage the dissemination of great design pattern respectful of privacy. So here, for example, CNIL worked with the French government's design system on the cookie banners, which will be spread around the French government's websites. So we just saw that it's important to accompany the dissemination of good practices. So let's dive a little deeper in CNIL accompaniment mission of design. In 2019, CNIL released its reports it's IP reports number 6. So you have it here. It's translated in English also. It's free online. And so the principle of the IP report is to take any topic and cross it with data protection. So in 2019, was interested in design. And so in this report, we saw that design shape the choices in the digital world. And that the interface is really the first object of mediation between the law, rights, and individuals. So it's really important for a data protection authority to connect with this design ecosystem. And so at the end of these reports, there were some kind of recommendations for data protection authority and the data protection field in general. And one of them was stating that there is a necessity for regulation to connect with design, to engage with the architectures of choice. And a precise recommendation was to help building non-competitive and open source approaches to best design practices. So just after that, Link tried to engage in this recommendation. So, well, maybe I can try to hide that a little. Okay. Well, okay, I think it's good. Then you can see we released our data and design platform, which is available at this link, design.cnil.fr, and there is of course an English translation. So feel free to have a look. Actually, I really hope that after my talk, all of you are gonna visit the website and use it on a regular basis. Because on the data and design website, what we try to do is to provide practical advices on how to implement legal design principles, but also case studies, which would be accessible for designers, so not in a juridic legal language, so that designer can, which are unaware of the regulation and don't have the time to deep dive in it, can have very practical recommendation to implement on their interfaces. But also we propose workshop toolkits and good practices and design patterns that can be useful for legal experts like you are, so that even though you don't have a design background, then you can easily understand the core of the principles and try to apply them in your work. So for example, what is available on this platform are a translation of the key concepts of GDPR to keep in mind if you are a designer who don't want to spend lots of time reading the GDPR, or if you are legal experts, but you want just have a more simple reminder of the key principle of this legal design approach. Then we grouped them in 3 principles around consents, which I'm gonna explain in detail today, around the information, and around exercise of rights. And for all of these principles, you can find them, all the details on the websites, but also we try to transform them in accessible tools for everybody to use and learn, even teachers and students. So, well, you can see perfectly here, but we also propose some tools. For example, this card deck that is also available online and that I printed in very big for you today, which explain this principle and make simple short reminders to have in mind. So let's dive deeper in the consent part. So I heard you had an introduction on data protection before, and then you had a reminder just before my presentation. So let's see if you remember. What are the core principles of consent? Can anybody remember any? Yeah? Yes, exactly. Freely given. And then? Specific? Yes, indeed. Specific. Yes, was the card I was holding. Easy. And then you have at least 2 more. Yeah? Informed, exactly. And finally? Exactly. So what does it mean with a practical example? So freely given, then freely given means that, for example, here in this example, then to go to the next step, you have to accept all the preferences regarding the use of my personal data. And So here the consent is not freely given because you are obliged to accept everything before going to the next step. So maybe it's a design glitch, maybe it's the architecture of the website which made that, but still it's not a freely given consent. So a possible approach is to make sure, for example, here, that as soon as you understand and agree the terms of service, then the going to the next step is not for going to go to the next step. It's not mandatory to accept and consent to the various preferences regarding personal data. So now an example for a specific consent. Well, here you have an example of a consent where you consent both to the use of the credit card details information and to the use of the email address to share with the partners. So actually the consent is not specific because both finalities are merged. So a possible approach, which is a lot easier for the user to understand, is to make this consent specific, but also contextual, to break down the consents into the various parts, but also to add them when the user is giving the information. Now for an informed consent, well, I'll use a joker because if I have the time, I'll speak shortly at the end of my presentation about information, because if you recall, information is one of the 3 key concepts of the GDPR. So I'll come back shortly after that. And finally, consent have to be unambiguous, a clear affirmative action. So what could it mean? In this example, for example, a chatbot asked to Hannah if she can give her email address for a specific finality, and then it asked her if she wants to receive emails of the partners. And as Anna doesn't respond, then the chatbots to some days after just start sending the email. So the consent is not unambiguous because here it's an inaction that is taken for consent. While here, in this example, we wait for a clear response of Hannah, is whether she sent yes or no. So that's our core principle that you always should keep in mind. Now let's dive deeper into information. So information, it's a legal obligation to comply, but also the transparency of the processing is one of the best way to establish trust with the users of your interface. So it's really an interesting key to make the service more usable for users. And you've just been reminded that most of the time when we speak about privacy information, we think about very long privacy policies. But we have very simple principles that would make privacy policies more accessible. For example, you have some obligation regarding the information. So you have a basic list of the information you should provide in any case. But also, I don't play with you to the card game, but you can do it between you or visit the website if you want. So, but also you have in the GDPR principles that actually are almost legal design principle. The information should be easily accessible. It should be simple and clear. It should be intelligible and concise. And it should be, of course, before consenting. So let's dive a little bit in what could be an easily accessible information. So I'm moving here so you can see. Okay. So in this example, well, people have to search for the place where the data protection and privacy information can be. While in this possible approach, we propose that. Okay, maybe I have a short glitch. Okay, yeah, maybe in this example, we see that it's not very difficult to make a really accessible way to give data protection information by just adding one item on the menu. And so it's just one click to have data protection information grouped in one place. Another principle, understandable, simple, and clear information. So we just, you've been shown another example. Here you can see that we have a very long sentence with very complicated and technical word. It's not difficult to split it's not mandatory to have this level of complexity, and it's not very difficult to split sentences in this way and make information shorter. And you have, with the plain language principles, lot of key concepts to know how long to make a sentence, for example. And you have lots of glossaries to know which terms can be simpler to use. And finally, information should be readable and concise. So here you have all the data protection information, but they are very dense, very long privacy policy after next button. So probably all of you are just gonna click to next and jump to the next screen. While here, a possible approach would be to break down into pieces the data protection and privacy information, and then to give them in a contextual way, precisely when the user is providing some information about themselves, to make them more connected to the context of the screen the user is seeing. So finally, we spoke about the obligations and how to make consent clear and transparent, as GDPR said. But on top of that, you can add good practices, which we call design patterns, and we propose some on the website, which are various ways to implement the principle of transparency even further. So just a few examples. Here you have, for example, a design pattern around how to structure your information. For example, using layered information, make sure that the user is confronted to a first level of information that is not too long and that it can go back and forth to having more or less detail. Another way to structure, but we explain lots of ways in the website, could be to structure by questions. This is interesting because it's more user-centered, as it's a more user-centered approach, but also it's great for SEO, search engine optimization, because when you do so, it's easier to reference the part of the privacy policy and the results that could be relevant when a person search for precise data protection information. And so on the website, we gave very precise guidelines on how to do that. Another very, very basic design principle that could be added to any privacy policy, but actually is not really in 2025 in most privacy policies, is to make the table of contents a browsing menu so that people can really easily have a kind of map, an overview of the privacy policy, but also easily find what they're searching for. Another simple principle is to make a summary of key parts of the privacy policy of one paragraph, or a recap at the end with icons, etc. So that even though all the details are here, you can have an overview. Another way of summarizing is to use tables when you have very complex and lots of kind of data processing. Then it can be easier for the user when it is searching for precise information to access it directly. And finally, you've seen these best practices were another level to make this information more transparent. And a final level to make this information transparent would be to use a co-design approach. So to co-design your interfaces with the user to make sure that the information is understandable for them. So we proposed, you can see here, we propose workshop kits, toolkits to do that, with the facilitation methods to make workshops. And we didn't took that out of nowhere. We organized workshops. With minors and with adults for various subjects. And that's how we made our facilitation kits. And also we gave them lots of different mission and testing interfaces. And that's what gave us the material for making our case studies. So for example, those 3 particular case studies are dedicated to a best way of giving information to minors. Yeah, and so finally, The last principle was around exercise of rights. So you have exactly the same methodology on the website. I won't go deeper today on that, but you can find everything online. But I will just mention one study we just released in January around that topic, because we wanted to have a state of the art of what is the current 2025 practices for constructing a user journey, a user experience around exercising our rights. So maybe you remember for the data protection course you had that one principle in the GDPR in the article 15.3 is that the provider, the controller should provide a copy of the personal data. So on that website, you can see that we tested the 10 major social media platforms to see what good practices are used or not used today in these user journeys. We tested these social media platforms, so some of the biggest, and we just show the percentage of the good practices which were used by each platform. And actually, it was really interesting because we saw that on average, 68 of these good practices that we were observing, we made a list of 30 basic good design practices that could be implemented on any exercise of right user journey. And we saw that these 10 major social media platforms that are supposed to have a great budget for lots of interaction designing the best user experience for exercising the rights, well, they only cover 68% of the 30 basic good practices. So it's interesting because even though it's a good score, we should ask ourselves if it's enough for the users, because they all automated the user journeys so that you don't have to exchange email with the DPO to have your data. And you only need 4 clicks to access from the homepage the form for exercising your rights. But on the other hand, each of those criteria are not that trivial, not that simple, because, for example, here, our methodology for counting the number of clicks was actually very complex, even though a click is just a number. So it seems very trivial, very simple. But here you can see that you need to find the good way to the good journey for searching the form. And even though you have it, you have, for example, 1, 2, 3, 4 clicks, but it's not enough to quantify the user experience, because when you have to scroll down, then it's making the user journey longer. So these are the things you have to take into account to observe that. Or, for example, when you have a search bar, which is another very simple criteria, is there any results regarding to right to access on the search bar, on the privacy browser of the website? It's a yes or no answer, but actually it's not that simple, because some social media platform has until 3 different search bars on the interface. So it's not at all instinctive for the user to know that one search bar will give results regarding to the right to access, but the other 2 won't. And so most probably the user will stop to one search bar and conclude that there is no information to be found about right to access. So all of these resources are, you can find them online, and I encourage you deeply to have a look to all of them. So our data and design website, but also our observatory of user journey of rights, especially because we made available all our methodology, and we would very like for students to reproduce these tests, because we can't test all the time. And so it would be great if you were also continuing this practice. Thanks a lot, and looking forward to it.
Thank you very much. It's such a broad topic. Sorry that you had to run, but it's now time for questions or observations. So let's dedicate at least 20-25 minutes for online and on-site participants. Just as information, if you need testers, we have digital clinics at the University of Geneva, where we make students in group projects. They work in different group projects, and